Good afternoon, everybody, and welcome to this follow-up session to our Africa session we had on the 22nd of April. I'm delighted to say that our speakers then, Commissioner Drudeisha Madhub, Professor Sizwe, Snail, Mtuze, and Advocate Lebogang Stroom-Nzama have all agreed to join us once again, because there were so many questions in that first session that we've now got them ready. We've put them on our website so you can see them. And we're going to go through the questions, and we're going to doing groups of questions. So the first group is for Mauritius, and we'll start right away. So the first question is Commissioner Madhub. Scope of the law: does the same registration requirement apply to sub-processors based in Mauritius if the processor is not based in Mauritius?
Yes, indeed. Thank you for inviting me again to present as Stewart. I'm very honored again. So yes, indeed, if the processor is not based in Mauritius, but actually the sub-processor is based in Mauritius, it will be the same requirement for registration, and he will be mandatorily required to register under Section 14 of the Data Protection Act.
Right. Okay, let's go to the next one. This is I thought it's a real question, but it's like a scenario. A US-based social media company with no presence in Mauritius and who does not use equipment in Mauritius process the personal data of people based in Mauritius. So will the company have to comply with the Mauritius data protection law?
Yes, it's not a yes and no or no answer. I will just explain how it works actually. If the company is not based in Mauritius and is not using equipment in Mauritius, the Data Protection Act is territorial in scope. It means that if we have a strict reading of the Data Protection Act, it means actually that the law will not be applicable in this particular context. But it's a big but here. I have to explain how we juggle with that section, which is Section 3.5 of the Data Protection Act, which provides that if the company is not established in Mauritius but wants to do business in Mauritius, he has to appoint a representative. That representative can be a Mauritian or actually a branch, an office, or an agency who is doing business in Mauritius, and they can do that via this representative in Mauritius. So this is how we tackle the issue of territoriality. But once again, to say, for example, that happened before the scenario, and we actually inquired into it. That was the Cambridge Analytica case, where we actually solicited the Irish Supervisory Authority Corporation with regard to Mauritian data, which were involved in the incident, the bridge incident case. And we wanted to know exactly how we could actually work together to be able, through the Irish headquarters of Facebook, to be able to get certain, guarantees, certain reassurances for our population that their data is not going to be hacked again, or we are going to secure their data. So this is how we work. Whenever we are not being able to approach the offender directly, we go via the corporation channel, and we solicit the help of our peers, and we've been doing that for quite some time already.
Right. So a company in this case must appoint a representative in Mauritius, so you have somebody to speak to, someone to communicate with the ultimate company. Right.
Absolutely.
Okay.
Yeah.
Move on to the next one. Is there a difference in the way that the law covers personal data on a server in the country compared with a computer accessing cloud data in another country?
No, there is no difference whether the server is located in Mauritius or it's cloud-based. Actually, because the controller or the processor will be established, will be located in Mauritius, so the Data Protection Act will apply in both scenarios.
Right. Okay, thank you. On to the next. I understand data subjects are living individuals. How is the right to erasure and rectification exercised with respect to deceased individuals?
The Data Protection Act relates only to living individuals, as is the case for GDPR and other data protection laws as well across the world. But when deceased information is being concerned, it is the Civil Status Act, the Civil Code, which will be made applicable to, to protect this type of information. So they work, they are actually collaborative laws where there is a panoply of laws which are applicable in these contexts, and it makes protection really efficient. So there is no issue like, because the Data Protection Act is not concerned with deceased individuals, it means they are operating in the vacuum. There is no legal vacuum. There is a strict a panoply of laws in Mauritius which are applicable.
Right, so no legal vacuum. The same rights that used to apply still apply. Good, thank you so much. And now we're going to turn to some questions for South Africa. So can we have our South African speakers on screen, please? Right, thank you. And Professor Sizwe, will you appear as well? So the first question is the role of the information officer. And there are a few questions on that. The first, is the portal to register information officers now available?
That one. Yes, we've had some complaints regarding the portal for registration of information officers. It was supposed to be active by the 1st of May.
Yes.
But a notice there notifying everybody that in due course the portal should be available. We're just going through some vigorous testing of the system so that we don't have any hiccups. I think that's the position that we can convey, isn't it, advocates?
So, yeah, so maybe the end of May, it'll be ready, something like that.
Yeah.
And there'll still be a duty to register, so everyone should get ready for that very soon. Right, thank you. Next question for South Africa. In terms of the information officers and deputy information officers, does the law state where these individuals should be located? Does the information regulator have a recommendation or guidance on this point?
Can I take that one?
Please.
Yeah. Yes. In case of a multinational company which is outside South Africa, that company must authorize any person within South Africa to be registered as an information officer or deputy information officer. The appointment must happen within the Republic. So meaning a multinational company must authorize somebody here in South Africa to take up that role.
Yes, so you've got to have a person you can speak to in South Africa, as long as it's in the Republic. That is the important point. Right. Thank you. Okay, that's clear. Well, that's a similar question, really. Does an information officer have to be appointed within the company and in the country? Or could this be person? Well, you've dealt with the country, but what about in a different, like a consultancy or something like that? Could it be, for example, could it be in the Republic of South Africa, but working for a consultancy or legal advisor? Would still be considered an information officer? So,
Stewart, can you raise your question again? Can you repeat the question again? The line is not clear.
Rephrase it. Yeah, so you've made it clear in your answer to the last question that a representative must be in the Republic of South Africa. But could that information officer be working for a third party, meaning a legal advisor or a consultant or an advisor in the Republic, but not an employee of company X?
Yes, that's a very key question. We also sought a legal opinion on that one, whether can the information officer be outsourced to a juristic person, meaning a company. The answer is no.
Right.
It's no. It cannot be a company. Yes, okay. We've got a legal opinion to that effect.
Right, so there must be an employee of the company, the
definitely
responsible company. Right, good, that's a clear answer, thank you very much. We're moving on to the next one. It's about registration. Assuming they are part of the same holding company, would it be acceptable in terms of the guidance notes regarding registration of an information officer and a deputy information officer, to have that information officer in the UK and deputy in South Africa. So in other words, could you have we know that a person has got to be in South Africa, but could it be the deputy in South Africa, but the official information officer, the top person in another country, such as the UK?
As far as we're concerned, the agent of the organization, right? In other words, if there's a particular company, a foreign company that is incorporated in South Africa, that agency company, the head of that organization would have to be the information officer. We do appreciate that companies could be part of other companies in other jurisdictions, but in terms of our law, we would like the head of the incorporated company in South Africa to be the one who is registered. Right.
So the information officer has to be in South Africa. Maybe the deputy could be outside. Is that possible? We just switch it around just for a hypothetical.
Well, that's an interesting one because, you know, of late we are electronic and everywhere, but I don't think in terms of the law there's any provision for that. I think technically speaking one could do that, but I don't think legally speaking that is authorized in terms of our legislation.
Right. I mean, that was not an official question. I just thought of it as we were talking. Maybe some companies would like to switch around. Anyway, you're quite clear. The answer is both the information officer and the deputy should be in Republic of South Africa. Okay. So we'll go to the next one. Yes, this person is, I'm not reading out the whole question here, but they're saying they're similar. Your requirements in South Africa are similar to the GDPR. And this person who asked this question is worried about the independence of the information officer if they're employees. I think they are thinking that they can't be truly independent if they're an employee, but obviously that is what the law requires. Have you thought about this?
Yeah. I think our legislation has been drafted in the way in which it has been drafted. So, you know, it may be a want-have or a like-have of a particular country or jurisdiction that, you know, PPA speak in that fashion. But unfortunately, it doesn't, you know. The PPA is quite, you know, straightforward about that, to say that, you know, the information officer must be from South Africa, and the role of the information officer is clearly stated out in sections 55 and 56. And, you know, that doesn't make the person necessarily not independent. The mere fact that you are empowered with these roles and responsibilities means that, notwithstanding the fact that you are employed by a particular organization, there are still certain rights and responsibilities that you have to exercise for and on behalf of the organization, be it to the advantage of the organization, be it to the detriment. And I think that is where the independence then comes out clearly, because you are in a way a functionary, and in a way you are also exercising and protecting rights. So I think it's a dual functionality, if I can put it like that. But I don't think the independence would be affected by that at all.
Right. Okay. Thanks very much. Move on to the next one. Yes. Can a company appoint one information officer for the privacy law and another one for the access law?
No. It's the same information officer for both PPA and PAYA. So it's one person.
Right. Okay. Short answer. Thank you. Next one. Yes, this one's to do with working within the manual and draft of course, the information officer retains accountability for monitoring and compliance. Maybe I should read the whole question. The information officer is responsible for developing and monitoring compliance against the PAIA manual and compliance framework. Can someone else draft the manual and framework, but the information officer retains accountability for monitoring and compliance around the manual and framework? So can you split the roles of writing the manual and doing the job?
I think in terms of monitoring the compliance framework, it's the responsibility of the information officer. Whether a company chooses to outsource the developing of the framework, it's the internal arrangements that the company will make. Ours is to come in as the regulator and ensure that there's compliance with POPIA. But those, I think, are internal arrangements in terms of who will draft the framework. The Act just say there must be a framework in place. So that's a decision, it's a policy decision that has to be made by a particular company, whether they develop the framework internally by using their compliance resources or they outsource it. It's up to them. Ours is to monitor whether there's a framework which is developed and monitored. Thank you.
Thank you. That makes perfect sense because, of course, one information officer after a few years could be replaced by another one who haven't necessarily written the manual. So your answer makes perfect sense. And the last in this section, section 30. Section 30 of the GDPR requires that each controller, and where applicable, the controller's representative shall maintain a record of processing activities within its responsibility. I understand that POPIA has a similar requirement concerning a record of processing activities. Could you please comment on what the similarities and differences are concerning a record of processing activities in terms of POPIA compared to the GDPR? Are there any main differences that you know about? Or do you prefer, I mean, some of these questions you might say you prefer to respond in writing if it's too complicated to deal with in this session.
It's actually quite interesting. When I saw this question, I actually paged to the relevant section in the GDPR, and I tried to look at the relevant part in the POPIA, and I think, yes, I must agree. This is one of those complicated questions that one should rather defer to a later stage.
Right. So maybe we could get a written response. By the way, we did have, the audience should know that we had a very detailed article in our recent Privacy Laws and Business International report looking at the comparison between requirements of processing activities in different countries. That was very worthwhile. Right, we're now going to move on to the next question, and we're turning our attention back to Mauritius and the role of the data protection officer. First question on this section: is there a threshold to the requirement of having a data protection officer? For example, do very small companies have to have a data protection officer?
There is actually no threshold requirement. That is, all big and small companies or organizations concerned, they have to have, it's mandatory. They need a data protection officer. And but the appointment of the data protection officer in the organization should not be conflictual in interest between other posts that, for example, a person is an information officer or the data protection officer is also a chief information officer together with a legal officer, because they combine and they merge so many functions in the company or the organization. But they have to be careful here, because there should be no conflict of interest between the different nominations that the person is over jobs that is actually holding in the company.
Right, so that's okay. So every company, however small, must appoint a data protection officer, but it should be a person who doesn't have a conflict of interest. Right.
Yes.
Thank you. Moving to the next one. So the first one is yes, every company has to have a data protection officer. Yes. And does it have to be a full-time independent role, or can it be combined with an existing role? Well, I think your response you gave to the previous question answers that. It can be combined with another role, but not conflicting, I think is the answer.
But I think I will just highlight that, yes, on our website, we have published a guide to explain, how the data protection officer should be appointed, what type of, qualifications, etc., that can be required from a data protection officer. So the document is on our website, and I've given the link to you in the paper that we have sent. So you can just go through it and see actually what suits you best. I mean, as the person you would like to appoint.
Okay, that's great. That's very clear. Thank you. So everyone should look at the website, which has a lot more information. Good. And we're moving on, and we're turning back to South Africa and onto the question of international transfers. So the first question is, what is the equivalent of standard contractual clauses which are available under the GDPR? We know they're being revised by the EU and indeed separately by the UK. But is there an equivalent in South Africa?
Yes, I think if one looks at particular Section 72 that deals with transfer of personal information outside the Republic, our legislation talks about binding corporate rules. So I think that is quite similar. I think it's literally semantics and language and in different jurisdictional things, but I think in essence, that would be the same thing.
Well, I just raised a question here because in the EU, binding corporate rules are take a very long time to negotiate and usually very expensive. Only about 80 or so have been adopted over a few years. So they are distinguished from standard contractual clauses. So do you mean that binding corporate rules in South Africa are the equivalent of standard contractual clauses in the EU? Is that what you mean, Professor Sizwe?
No, I don't think I can bind myself to that answer. I can bind myself to the extent to tell you what Section 72 says. And it is in that context where I say that, there may be similarities between the two. But I can't take the discussion further on that.
Okay, we better move on then. Next question, what clauses are required in intercompany agreements to allow information processed in South Africa to be transferred outside the Republic to a company, for example, based in the UK? It's an example. Do you have model clauses or guidance on what those clauses should say?
No, I don't think there's any model clauses, but once again, I think one ought to refer back to Section 72, which in essence talks about allowing you to transfer personal information to another jurisdiction where there's adequate protection of personal information, and if in that event there is none, that at least contractually speaking, that company and the responsible party that's giving the information from South Africa have agreed to, contractually respect data protection rules.
Right.
At this stage, I'd have a copy of my legislation here.
Right.
And adding to what Professor is saying, we'll be developing a guidance note on trans-border information flows. So I think some of these issues will be unpacked on our guidance note. Thank you.
Okay. So the guidance, when do you expect the guidance to be ready? Will it be by July the 1st? Sorry, you're muted. I can't hear you. I can't hear anything.
Oh, sorry, I can't commit to the date, but it's one of the documents that we are busy internally working on. So once we are ready with it, we'll publish it obviously on our website for comment.
Sure.
Yes.
And are you planning to have a list of adequate countries, or will you just accept the EU adequate countries? You may have a different.
That's a policy decision by the regulator. I can't give my own view. So once we interrogate 72, we'll be able to sort of give you more detail in that regard.
Right. Well, yes, I know this subject is very important for everyone. So maybe after you've published the guidance note, we may want to go back to this subject. But this is similar to the question we had for Mauritius. Is there a difference in the way that the law covers personal data on a server in the country compared with a computer accessing cloud data based in another country?
I think the answer will be similar to that of Drudeisha, to say that even if the cloud server is outside the jurisdiction, we're looking at the person, or should I say the company that's actually processing the personal information. If that is happening on the instructions or literally in the Republic or by way of means of communication from the Republic to this cloud service, then our law would apply. I think that's relatively simple.
Yes, otherwise I suppose companies in South Africa everyone could use cloud services, and then the law wouldn't apply to anyone. So, I mean, it's perfectly rational in terms of you having jurisdiction over the companies operating in South Africa. So that makes perfect sense. That's a personal comment. Right. Well, does the South Africa recognise the EU as offering an adequate regime for protecting personal data? And if the transfers to the EU, can they be done freely without any additional transfer?
Well, I think Advocate Stroom has already answered that we do intend drafting a guidance note, in particular on the aspects of transporter sharing of personal information. But with that having been said, without making any pronouncement on the GDPR, I think one can safely accept that the general data protection principles as contained in the GDPR are also contained in the PL. And without an official pronouncement on adequacy, I mean, we don't even talk about adequacy as they talk in the GDPR, but without an official pronouncement on that, I think in terms of international best practice, in terms of international conventions related to data protection, I think one could safely say that South Africa is a safe place for data protection, and likewise would be Europe. That's
right. Yes, thank you for that unofficial reassurance. Right. Okay. Well, I think the answer would: EU binding corporate rules be considered adequate for transfers of data out of South Africa. So, for example, a company, one of the on the list of binding companies with binding corporate rules. From what you've said before, I'm assuming that any company which has won its an acceptance for its binding corporate rules, that would presumably satisfy the South African regulator. But let me know if I'm wrong.
I think Stewart, this is another one of those which I think the guidance note will give more clarity on. So you will have to appreciate my minuteness in terms of a response.
Right. Okay. A bit of caution there, but I understand. All right. Thank you. And now we're turning back. Thank you, South Africa. We're now turning back to Mauritius, and we're talking again about international transfers. So it's a general question. First of all, how is international flow of data managed in Mauritius for transnational business? But you deal in more detail. Do you want to do any general comments before we go into the detailed questions?
No. I mean, I have quite some issues to address, so please.
Should we go on to more detail?
Yes.
Right. So data in transit. What is data in transit compared with data not in transit?
Sorry, I didn't understand you, Stewart. Are you going to get to that question on transfers again, or because I have a lot of...
Oh, no, if you want to make... Yes, please go ahead. If you've got some general comments, yes, please go ahead.
Thank you. I just wanted to highlight that, we take cross-border data flows very seriously here in Mauritius, and it's very heavily regulated as well. But we have, given some flexibility now in the new Data Protection Act, given the context of the EU GDPR and the international standards in trend. So now there is no need for authorization from the commissioner, as it used to be the case before, the old law, for every transfer that is effective from Mauritius to abroad. But we have Section 36 of the Data Protection Act, which regulates transfers, and there are a set of criteria where actually you have to respect them before actually we can, if we have to authorize, we will give you authorization if you respect that section. If there is no authorization concern, you have to fall within one of the exceptions that have been provided in this section. Let me explain very clearly. I think that would be most important here, because the section provides, like, if you're coming to the commissioner to say that I want to transfer my data abroad, you need to adduce evidence of appropriate safeguards. And if you're not able to do that, you will actually not be able to transfer the data abroad. And there are other exceptions, like if the data subject has given his consent, there are contractual provisions involved, like standard contractual clauses, including binding corporate rules as well, because all these are contractual requirements and they fall within this section. And there are like reasons of public interest, legal claims, vital interest, legitimate interest. All these are, if you fall under any one of these grounds, actually you can transfer the data abroad without seeking authorization from the company. But otherwise, you will have to seek authorization if you're not able to buttress or support yourself with any one of these criteria as elaborated in the law. And also very important here is that why we chose to ratify Convention 108 Plus is because we believe it has the same principles as in the Data Protection Act. And we want to create these, regional safe digital spaces or common markets where we can actually work together and make cooperation possible between blocks, let's say Africa, let's say other parts of the world as well. So where there are issues like adequacy is a big issue for EU, we can actually work in ways where we can make cross-border data transfers possible with the appropriate safeguards incorporated. So I just wanted to highlight on international transfers.
Yes, thank you. That's very helpful. So organizations do, generally speaking, not require permission because you drop that requirement, but there are criteria in the law for exporting personal data. And in terms of big picture, Mauritius has signed and ratified the Council of Europe Convention 108 Plus, and you aspire to having sort of regional groupings working together on trying to encourage the signing and ratifying of Council of Europe Convention 108 Plus, which will then give a sort of safe zone for the transfer of personal data.
Yeah, otherwise I would like to add here, sorry, I forgot, is we do make trade agreements possible as well, mutual assistance and other bilateral agreements. And these are happening in Mauritius right now. I've been vetting many of these documents where we do trade with one X country or a bloc. And these are actually, standard contractual clauses or binding corporate rules or whatever name you give it, trade agreements. They cover many aspects, including data privacy principles as well.
Right. Okay. Thank you. That's a very good general statement. I think it's very clear now. And so now we come to the next thing about the term data in transit. What is data in transit compared with data not in transit?
All right, so I will have to define exactly what is data in transit. I mean, this is data actually moving from one network to the other, depending on it doesn't depend on barriers. I mean, countries from country X to country Y, or even within internal or external. So this is just data in motion, and here there is no respect for geographical barriers. And actually, this is where it's very, very difficult to implement data privacy safeguards when data is in transit. So the Data Protection Act does not apply to data which is transiting that way because it's not possible to control this type of data. But when the data actually resides in one of our servers or in Mauritius, or, then it's possible to say that the Data Protection Act will apply. So the risk with data in transit is really big because security measures have to be really, higher than data which is secured in a network based in a particular country. So here, that's the point, is that The data protection does not apply to data which is transiting only from Mauritius, because that data will not be stored in any of our servers here. So that's why the Data Protection Act does not apply.
That makes perfect sense. So data is passing through, the law does not apply. If it stops in Mauritius and it becomes on a server in Mauritius, processed in Mauritius, the law does apply.
Yes.
Great. Thank you, very clear. Move on to the next one. Are we allowed to have a bulk application through the record of processing activities to seek the Commissioner's approval regarding activities related to cross-border data transfers? They want a sort of bulk approval. Is this possible?
Yes. Here we have to make the distinction between what we have here in Mauritius, the transfer of personal data form, which is on our website, and the record of processing operations template. They are two distinct obligations under the law. You're required under the law to keep a record of processing operations, but you're also required, where authorization is required from me to transfer the data abroad, there is a transfer of personal data form, which needs to be filled by you for you to seek authorization from me. So we have to make the distinction between these two. They are not the same. Transfer is one, record of processing operations is another. But you can make a bulk application if it relates only to your organization. That is, one single organization can make bulk applications for all its sub-entities operating under its aegis. And that is possible. Let's say a multinational making a bulk application for all its entities for a transfer of personal data. This is possible, but record of processing activities is also, you just fill in the template. It's on the website, and it does not depend on whether it's bulk or not. There is no restriction, but you have to see whether you fit in the requirements contained in the template that we have provided. So, but basically there is no restriction in both scenarios.
Right, thank you. So everyone should look at the website and fill in the templates which are there. Right.
Yes.
Thank you. Right, thank you so much, Mauritius. And we turn to South Africa again. And the next question is on consent. We're doing customer satisfaction surveys for clients. They give us their customer list. Is it allowed to email these data subjects regarding the service that was provided to them, or do they have to opt in?
Okay, so this one is it's an interesting one. I think I'll take it. You know, in terms of Section 69, we have the whole opt-in provision, as you have stated. However, if you are a customer of a particular company and it is in relation to the same goods or services, then it should not necessarily be a requirement that that responsible party should require any further consent. With regards to the operator, in other words, the third party now that may be doing the work on behalf of the responsible party, that will throw us back to sections 19, 20, and 21, which would require a written agreement to be entered into for that specific party to do those services on behalf of the responsible party. I think that's a straightforward answer that we can give. In other words, yes, in terms of the responsible party and its own customers, there is no further opt-in requirement, but that operator must have an express agreement with the responsible party to ensure the protection of the personal information that's being processed on behalf of the data controller. Advocate Stroom, do you want to add to that?
Yes, Prof. You're correct. I think the key phrase there is that existing customer. So if it's an existing customer, you don't need to get another consent. That's the key word there. Thank you.
Yes, and also we should have said that the term operator in South Africa is the same as processor. Responsible party in South Africa is the same as controller in the EU. Right, let's move on. Legal persons. How does the information regulator expect responsible parties to apply the principles of POPIA to information concerning judicial rather than natural persons? Will the information regulator be publishing guidance on this point?
Stewart, I think I'll take that one.
Okay.
In terms of our legislation, we don't talk about judicial persons, but rather juristic persons. You must remember, and we have a constitution, and I think that is the antecedents of the application of the POPIA to both natural persons as well as juristic persons. Juristic persons, if you look into the definition, is a existing company, existing partnership. That is the context of data protection in relation to a natural person where it would be a person. I must, however, say there are a lot of pieces of legislation that require a natural person to make a lot of disclosures about themselves, be it their registration number, the name of the company, the holders of the shareholders of the company, etc., etc. So I think with regards to that, the regulator will definitely be publishing a guidance note. And I think it will be sooner than you think, because it's not the first time that this has come up as a question. And as we know, the first of around the corner. So watch the space on that.
Yes, certainly the trend in the EU for those few countries which covered legal persons in its original data protection, their original data protection laws, they mostly dropped the point. Like Italy covered legal persons at one stage, but then after a few years they dropped that. So most laws certainly just cover natural persons. Right, let's move on. We're still at South Africa, another one on legal persons. Well, I think you've already answered this one. Does South Africa provide an adequate level of protection of legal entities? You've said there will be a guidance note coming shortly. So I think the person who asked this question should wait to see the guidance note, and then we'll, if you have further questions, we can take them up at that stage. Let's go on to the next one. Mauritius, special categories of personal data. Regarding the Mauritius example of biometrics in identification systems as an emerging offshore financial center, how you and financial services regulators you're approaching privacy enhancing technologies in relation to authentication techniques such as biometric fingerprints or eye retina scans, and referring to strong customer authentication under the PSD2 in an EU or UK context.
Yes, definitely. I just had a small chat with the financial regulators to confirm whether actually they had the model strong customer authentication under PSD2, because we were not aware whether they had it or not. But they have given me the assurance and orally that they have actually a similar type of authentication, incorporating the privacy enhancing technologies involved, and they are shortly going to give me an official answer to this. So I think rest assured that the financial sector is well governed by privacy by design principles and PETs, and also because they are registered as controllers or processors with the Data Protection Office, and they have to abide by the provisions contained in Section 31 of the DPA, which relates to appropriate security and organizational measures that they have to put into place to be able to ensure processing is done lawfully. So they are already under this legal obligation and they have to fulfill it. And they also are performing data protection impact assessments, where actually we will be able to determine whether they are in compliance as they should with the requirements of the DPA. So I think basically that is the scenario right now concerning the financial sector, and it's safe. There is no problem right here with special categories of personal data.
Yes, well, thank you for letting us know you're going to get an official memo from the financial regulator. Would you let us know when that happens, and then we can direct people? Presumably you'll put that on your website, will you?
Yes, we can do that, and definitely. But normally we don't publish. It's confidential information. We don't publish that type of information. But anybody who wants to send us a mail and wants to get more information, we can actually rechannel the person to the Bank of Mauritius, who has given us this information, and they will be able to tell the person exactly what it is and how they're handling the processing in Mauritius.
Yes, that sounds a very, very good solution.
Yes.
So those financial organisations particularly interested in this point, contact the Commissioner, the Data Protection Commissioner, and she will forward that to the financial regulator. Great. Okay, thank you. Right, so this is a more broader question. A broader question: is consent compulsory for the processing of special categories of sensitive data under the Data Protection Act 2017?
No, it's not compulsory in all. It's just one of the lawful grounds, one of the legal basis that is provided in the Data Protection Act for processing to actually take place. But let me explain that special categories of personal data, as a matter of rule, it's prohibited. The processing is prohibited. But in the exceptions which are found under Section 38, Section 28 and 29 will be applicable to allow the processing of special categories of personal data. But as a matter of rule, it's prohibited. So you have to fall under these exceptions to be able to process these sensitive data. Section 28 here is the lawful processing of personal information. There are a number of grounds that you have to satisfy. I will not be able to cover all of them. And then you have Section 29, which relates specifically to special categories of personal information here. And so both Section 28 and 29 have to be made applicable together. They are complementary. And so there's a lot of requirements for you to satisfy before you can actually process special categories. They are just safeguards to make sure that you're doing it in compliance with the data protection. They are not restrictive in nature, as Section 28 concerns contractual requirements, vital interest, legitimate interest, public interest, and the same scenario in Section 29 with some other novelties. So if you can claim one of these criteria, then you can process special categories, but consent is not the only ground or compulsory ground under the Data Protection Act. Right, thank you. So in principle, the processing of special categories of sensitive data is prohibited, but if you look at sections 28 and 29, you'll find all sorts of exceptions which will permit you to process sensitive data if you fulfill the requirements. Yeah, and consent is one of them. Consent is one of them, yes, thank you. Right. Okay, we turn back, thank you. We turn back to South Africa now, and some questions on the information regulator as a supervisory authority. Will there be a certification process for information officers or service providers assisting entities to get compliant? That is, so what's the answer to that one?
No, there won't be any certification.
Right.
Anything, there will not be any certification.
Right, thank you. In fact, this question came up in the United Kingdom yesterday, where the Information Commissioner had an all-day conference with very many members of a team, and there was a whole session on this, and there is certification being planned in the UK after having a law here since 1984. So I'm not surprised it's not a first requirement in South Africa. So anyway, that's the answer. No, you don't need a certification process in South Africa. We're on to the next. In what instances or which instances will the regulator not take action on complaints? So let's see what the answer is on that one. But that was the way it was put.
Yes, Stewart, that is regulated in Section 77 of POPIA, that the regulator, after investigating a complaint, And if it may decide not to take any action, if it's in the regulator's opinion, then it lists 5 grounds that, including but not limited, if the complaint is trivial, is frivolous, vexatious, it's not in good faith. So there are listed grounds in Section 77 of POPIA where the regulator, after investigating a complaint, may decide not to take an action on a complaint.
Okay, that is very much consistent with data protection laws everywhere. So certainly South Africa's in the mainstream on this point. So thank you for that. We go to the next point. Well, that's a broad open question. What challenges does the information regulator envisage regarding enforcement? Where do you see the problems regarding enforcement in future?
I think the issue with enforcement lies primarily in the fact that people have to appreciate that the regulator will have quasi-judicial powers. In other words, in South Africa up to now, for instance, and I'm using the example of access to information, if you would like to pursue a request for access to information and this is refused, you would have to approach a high court. Now, you will have this one-stop shop that will be giving enforcement notices, like I said, of a quasi-judicial nature, with an enforcement committee where a retired judge will be sitting. So I think it will take time for people to appreciate that there is this body called the Information Regulator, and that it does have certain powers, and that should you be seen on the wrong side of the law, unfortunately you may find yourself being exposed to administrative fines or other possible sanction. So I think those are the teething problems of new legislation and making everybody understand the consequences. I know there's a big critique to say, but the POPIA has been there since 2013. Well, the Office of the Regulator has only been here since December 2016. And we all know the grace period is ending now. So I think in terms of enforcement, we will start seeing more rigid type of enforcement. I mean, for now, we haven't enforced anything. We've just been proactively encouraging compliance and handling complaints. But once, like I said, once the law fully kicks in and people actually do suffer the wrath of the law, I think we will start seeing challenges to our decision. Our system allows for review of the High Court, so we will see. We will see how the law will be tested. I think that's how I'm going to answer that one.
Yes, and the law will settle down. The processes, people will challenge you, but that's the way laws, new laws, any law works. That the regulator regulates, then some people appeal, and then there's a growing understanding of what works and what doesn't. Okay, thank you. And still in South Africa, this is to do with the independence of the information regulator. Can we expect the information regulator to be tough on the public sector? The questioner says that the information regulator is very close to the Department of Justice, and even the website is .gov.za. So they're worried about will the regulator be deferential or be spirited and independent in relation to the government?
If I may,
okay.
Sorry, Prof. Continue, Prof.
Oh, okay. Sorry, Advocate. I just wanted to say, and I'll allow Advocate to add, that independence is in the mind. In other words, the fact that the regulator has been using the Department of Justice as a conduit to establish itself in no way suggests that the regulator will not be independent. The law is straightforward. Section 39 says the regulator is subject to the law and only the Constitution. So I see no reason why there should be any form of discrimination or any form of not pursuing a party because it's a public entity. Advocate Stroom, do you want to add to that? think
Yes,
we
thank you,
discussed
Prof.
this one.
Yeah, I think you've covered most of what I wanted to cover. The regulator is independent, is accountable to Parliament. We're monitoring public bodies the same way we monitor private bodies. And the issue of the Department of Justice is because it's a conduit. We remember we were just established, we didn't have a building, we didn't have anything. So we need to separate also in terms of the finance and HR system from them. But we are very independent from the Department of Justice. We're just using the systems because we need to acquire our own staff and our own building and everything. But we are independent from justice. It's just a conduit in terms of process. Thank you.
Right, thank you. That's a clear statement. The Information Regulator is and will remain independent regarding the central government and other public sector bodies. Right, we're back to Mauritius and Data Protection Commissioner as a supervisory authority. Okay, some EU supervisory authorities are criticised for not exercising their sanction powers, punitive powers in fines, and some are fined more heavily than others. And the questioner says the UK and Irish regulators are viewed being more conservative, that means sort of pragmatic or business friendly, than their French and German counterparts in this regard. What is your view on the exercise of such powers, and where do you think Mauritius is along the spectrum of more business friendly or more or stronger, or an authority which applies its full powers more readily?
If you will allow me, Stewart, I just wanted to make an additional remark to the certification, a question that was put to South Africa. It's good to note, I pointed out during my presentation before as well, that Mauritius in the Data Protection Act has a particular section on certification. That is, we are a certifying body, and we actually are in the process of certifying ABSA Bank in Mauritius. They have submitted their certification requirements, and they want to be certified by the Data Protection Office. So we are already doing that in Mauritius, just to add to this particular question.
So they're the first organization?
Yes,
they are
the first organization, and we have actually completed their certification exercise, and they will become, they will be granted that certificate very soon. So I just wanted to highlight this, that Mauritius has this particular function as well, the Data Protection Office. Coming back to this question, definitely, I'm not going to pronounce myself on the French, the conservative versus the non-conservative approach, but definitely for us, the question of leniency or heaviness does not even arise, because we have criminal sanctions in the Data Protection Act. They are all serious in nature, and that is not something we can dispute. So it's either a fine or imprisonment that is going to be inflicted by what we call here the intermediate court if the person is prosecuted. When the person is prosecuted, it moves from my jurisdiction to the jurisdiction of the intermediate court, and the intermediate court will give a judgment like any court will do, and that will be the sentence that will be inflicted on the defaulting party. So this is the offender, and that's how we operate in Mauritius. So the question is not about leniency here, and we just have to follow the procedures. And as you know, my decision, once I give my decision to recommend prosecution, people have the right to appeal against that decision. They go to what we call the ICT appeal tribunal, and if they are not satisfied, it's an appellate procedure which goes up to the level of the Supreme Court. So there is nothing like leniency here. We cannot play with that. We just have to give the verdict and the decision that we have to give, and that is how things are. And all prosecutions have to be instituted with the authorization of a director of public prosecutions. So it's very serious. We don't play with that. So this is what I wanted to say on that particular aspect.
Right, and so it's a serious legislation. You are a serious regulator. You have both civil and criminal powers, and everyone should note that Mauritius is a place which is operating fairly, but within a proper judicial system.
Yes.
Yeah. Okay.
Yes.
Okay. Oh, yes, I want to know this. The next question is, how is your office funded?
Okay. Yes. First of all, is that in my functions, I'm completely independent, and I'm not subject to the direction or control of any other authority. And this is the same like in the EU GDPR. And but my budget, it comes from the Ministry of Information Technology, Communication and Innovation, and we operate under the aegis of the ministry. Our budget is funded by the government, and it's managed by our parent ministry. But this budget that is attributed to the Data Protection Office, actually we use all the money most of the time, and we don't have issues with approvals like to get funding. So it's just a procedural step that we have to do with the ministry. We have to ask clearance for financial clearance only, whereas the other functions of the Data Protection Commissioner are completely independent, as we've got this section here in our law which says so. But financial independence, I would say from my point of view, to be very honest, we never had big issues with finance. I mean, it's just procedure. We apply, we get the funding, we justify, it goes for the government channel, and we get the money and we do what we have to do. But where there are restrictions, it's actually restrictions concerning every department in public service, and it's not only related to me being independent, that's why I don't get the funding. So there's nothing like bias here. I've not encountered this up to now. And if they don't want to give the money, they won't give you, they will give you justifications why they cannot give you the money. So that's how it works for every public office.
Right, so you submit a budget request, the government gives it to you, and I think the person is asking, do you keep if there's a fine, do you keep it in your budget?
So if there is
a fine on a company.
Oh, no, we're not allowed to do that. No, it's the court procedure. It's the intermediate court which charges the fine. It's not within my jurisdiction, and I cannot bring that money back. The money goes to the government budget.
Right.
And yes, and the registration dues and fees collected by the office also goes to government budget.
Right, you've been very clear. Thank you for that.
Yes.
Excellent. Right. Well, I realise we're in principle out of time, but we're so close to the end, I think we should continue, if you don't mind. So EU adequacy, an EU adequacy decision is important for the offshore sector Mauritius, especially for those doing business with Europe, and therefore processing personal data of EU citizens. Regarding the application process, so you said in your previous session, the government has put in a request for EU adequacy. When do you think that Mauritius will get a response? In other words, when do you think there'll be a decision on whether Mauritius will win an EU adequacy declaration?
Actually, we are at the stage of finalizing the consultancy nomination, and very soon a consultant will be appointed. So we are just at the initial stage of the process, and it will take around 4 to 5 months for that report to be ready. And after that will be sent to the EU for their own perusal, and the EU will take its own time to decide when to grant adequacy or not, what would be the additional information required from our office. But we have already facilitated the negotiations by informing them that we are actually at this stage, we are going to submit to them this report. But given the COVID situation right now, it's a bit difficult for the consultant to start work right now. So we are being delayed a little bit in that aspect with regard to the consultancy project. But I hope that this year we will be able to finalize the consultancy report. And once it's done, then it goes to the EU for their reading.
Right. Okay, that's clear. The process has begun, and maybe there'll be a decision. The consultancy report hopefully will be in by the end of the year, and then maybe we could have a decision, or the EU will make a decision next year. Right.
Yes.
Okay.
Yes. Yeah.
Very good. And we turn back for the next session, the last couple of questions, to South Africa. So the question 35 on the list is, the scenario is that a responsible party has contracted the performance for background checks, including criminal records on applications for job vacancies. Who should submit prior authorization? The responsible party or the operator contracted by the responsible party?
Advocate, you're going to take that one, or should I?
Proceed. I'll add because it ties on the question that Stewart has just sent before we log in. You can proceed. I'll comment on it.
All right. Okay. Awesome. So looking at this scenario, right, the responsible party would obviously be the one wanting to seek the information of the data subject, right? So this isn't a situation, I think, of prior authorization per se. I think in this one, it would be a situation of literally giving consent and alerting the data subject that a particular service provider may be used in order to do certain checks. Let me give it further to advocates.
Yeah. The section 57 of our act talks about the responsible party must obtain prior authorization. So it's more on the responsible party than the operator. But we would like to write to a written comment or respond on this one, since you have sent a question. I saw it 5 minutes before I logged on this webinar, that we give you a formal response, because I saw a comment on our guidelines for prior authorization, then there's a comment on what we had on the document. So can we respond to you in writing so that we can to that and give you an informed response in that regard? Thank you.
Yes, thank you. Some of these questions are too detailed for a verbal response, indeed. Right, the very last question is very specialist. In the case where an accountant is a trustee of a, oh, sorry, I haven't been moving it forward. Yes, in the case where an accountant is a trustee of a trust and is appointed as the information officer of the trust, how best can they enforce their responsibilities across the beneficiaries and other trustees? A bit of a technical question there. Who would like to answer that one?
Okay, so we debated this one with Advocate Stroom, and you know, we came to the conclusion to say that, well, first of all, the trust would be a responsible party.
Right.
The fact that the accountant, which would most probably be the independent trustee, that he or she would be nominated as the information officer by the other trustees, that would obviously have to be done in terms of the laws of the trust. So I think one way of entrenching, you know, the information officer would be by way of amendment of the trust deed itself, to say that, look, so-and-so will be the information officer of the trust, and set out, you know, the rights and obligations. But like I said, you know, this is not a formal response from the regulator. It's something Advocate Stroom and I debated prior to this one. We didn't want to give you a we don't know answer. We pondered over it, and I think that would be the correct approach. Right.
Okay. Well, thanks very much. I can see we have gone right through all the questions, and we have taken a bit longer than we originally planned. But I think I thank all the speakers for joining us today. Drudeisha Madhub, Data Protection Commissioner in Mauritius, Professor Sizwe Snail Mtuze, and Advocate Lebogang Stroom-Nzama. Thank you all very much for sharing your expertise with us. And we do realize there were some questions which you said you prefer to answer in writing, and which we will wait to receive those and then pass them to the group. Meanwhile, I saw there were many other comments in the chat, but we've not been able to deal with those. But I suggest that when the law comes fully into force in July, maybe we can, and you've issued some guidelines like on international transfers, we might seek to have ask you whether you'd like to have another session. But I think you've been very generous with your time and your expertise, and our privacy laws and business community is extremely grateful. I think the picture in Mauritius is clearer because you're so well established, but we might come back at another time. But meanwhile, Commissioner Madhub, you've provided us with many detailed answers in writing, which we will provide to the group. But we'll let you know if there are any follow-up questions. But I think you've almost certainly answered every question very fully. So I will bring this session to an end, and I will point out that we have some more sessions next week on the 13th with the Jersey, Guernsey, the Isle of Man, and the UK, international transfers. We've got an Asia session on 18th and 20th of May, and we have roundtables for each day following that, and then a China webinar on the 26th of May, and we have other sessions following as well. So I'd like to thank you all. We apologise for being a bit later than planned, but I think it was better that we've given full answers, and we look forward to being in contact with you again in the future. So I'll say thank you and goodbye.
Thank you.